what advice would you give young lawyers that are coming up right now who are facing this issue?
I think one thing I would say is work for lawyers who have the experience, the trial experience, the lawyering experience that predates that. So you can at least see how they operate and learn the various anecdotes that they have to give you.
Learn the technology and help to enhance your skills and your firm skills. And that's how you make yourself valuable to the partners or people with names on the door.
We think about, what should we be telling young lawyers? The other is, what should we be thinking about as older lawyers, or what should older lawyers be thinking about? Howdy, and welcome to the show. This is the AI episode. We do this about once a month, and we actually have a full contingent today. So we're back with Shahrad Milanfar and Marshall Cole. Marshall, nice to have you back after some time away. Again, sorry about your father's passing. I know he was the kind of the patriarch of the firm. So
Thank you very much. Thank you, Sam.
And likewise, I appreciate you taking the time, because I found out just before we started that you're starting trial on Tuesday, it sounds like, in another case.
Yep, ready to go. So no time off, just crank them.
Yeah. And Shahrad, you're coming in from having just been in trial up in Shasta County, where I understand face tattoo is the new black.
Yes, there were a significant number of people near the courthouse with face tattoos, and they were all unfortunately going into the criminal side of the courthouse. So that might be easy pickings for the cops up there.
Interesting. Very interesting. Well, in large part, thanks to Shahrad, we've got a fascinating outline of some high points in the world of AI and technology and the intersection of law. I think the one that I want to start with, as long as it's okay with the two of you, is Joe Joven versus Dreyer's Grand Ice Cream, terminating sanctions out of Alameda County for some bad behavior. And while it's not specifically on point on the AI or tech side, it is the use of technology behind the scenes in terms of an attorney texting a witness during deposition. And Shahrad, I think you brought this to our attention. Did you want to? I'm torn between Shahrad or Marshall, because Marshall, this seems like somebody who unfortunately you might end up having to defend at some point.
So basically, this particular attorney was apparently coaching a number of witnesses in this employment case and telling them what to say and what not to say while the deposition was going on. And the way this came to light was one of the witnesses was looking down, and they could see a reflection in his or her glasses indicating that she was looking down at a phone. And when they asked the person, is somebody texting you? The response was, yeah, defense counsel is texting me. So it kind of started to go down this rabbit hole. And eventually motions were brought for terminating sanctions. And the court in Alameda County basically said, I'm going to postpone basic terminating sanctions, but I'm going to impose $84,000 in monetary sanctions in the case. But this is kind of your opportunity to get out of this courthouse before I lower the boom on you. And the defendant ended up settling the case before the terminating sanctions were issued. But I think the monetary sanctions did go into place.
One thing before we get Marshall to weigh in on some of the, is there likely to be any E&O carrier involved, et cetera, is an acknowledgement that on the firm side, the defense firm where this was going on, the attorney was immediately ejected. So it did not appear like this was something that the firm itself was sanctioning.
Yeah, I think, since we've gone remote, which started at COVID with respect to depositions, one question I think all lawyers need to ask is the question that this lawyer asks, I think by coincidence, because he or she saw the reflection. But you need to ask whether there's anything on the screen that they're looking at, whether they're communicating with anyone. And you need to ask it, I think, after each break, because this witness was, honest, which they're under oath, so that's good, and testified that she was communicating. It's clear witness coaching. It's improper. I think the judge, gave the sanction that they deemed warranted, given what transpired. I can't be critical of that. And, it's also, I think, a stark warning to us lawyers that if you do things like this, you can get in some pretty serious trouble. I mean, when we were in person pre-COVID, you used to maybe like you kick your client under the table, right? Or like put your hand in front of them. I just had a video depo that was in person 2 or 3 weeks ago where the witness was started to answer really bad, and the lawyer just stopped it. And of course, it's on the record. And but the lawyer didn't care. It was like, I'm stopping him. You do whatever you think you want to do, and it'll play well at trial. But that's how we used to have to stop it. Now you can text, you can do things, and it's totally improper. So if you're doing it, you should stop. It's improper. And if you're worried about it being done to you, you got to ask the questions in depots to get ahead of it.
I mean, it seems so short-sighted to do something like this because presumably this person worked so hard to get their law license and get a job at this big white shoe firm and become a partner. I think the person was a junior partner at this firm. And then to do something like this, to then throw it all away is just foolish to begin with. But I think, since COVID, it seems like the lines in terms of what is acceptable in terms of defending some cases has been blurred, at least some of the stuff that I've seen. And maybe for depositions, we have to be more stern in the way we do admonitions so that the witnesses understand that there's serious consequences for this type of behavior and they need to be transparent about it.
The two takeaways I'm having from this conversation is what Marshall said about asking questions about whether there's anything else on screen and some stern admonitions. I think, unfortunately, there's stuff that one cannot really see and not know, and some of that will come to pass. But
look, if the witness is going to lie, the witness is going to lie. But I think it makes a case for videoing remote depositions because what you can see is where their eyes are. And if you consistently start to see them looking at one particular place, that's a clue. And they may deny it, but it's not going to stop you from making the argument in closing that, oh, look at all these answers, how convenient they were when that person looked in that direction. And so I think videoing him is important, especially if it's the plaintiff or the defendant or a PMK, any critical witness that you think might be coached. I would video it because it's easy enough to catch it. And you may not even see it in real time. So it's important to have that.
And to make sure that the opposing lawyer is on camera as well. It's the old adage of trust but verify. And unfortunately, we've come to this.
just so I make sure I tie the whole conversation up, Marshall, I alluded to asking you about E&O carriers. My guess is even though the junior partner was no longer with the firm, that given how much money had to be paid and had to be paid quickly, that there's likely to be some post-payment action involving the E&O carrier. Is that a fair supposition?
I think it was a big firm, so my guess is they wrote a check, and that will be that. If it's a small firm, they certainly could try to get their E&O carrier involved, whether there be coverage for a discovery sanction. I don't know that there would be, because it's not a claim that's being made against the firm. It's a sanction based on conduct. If the client paid it, certainly that would be an issue for them. But here, I think, the firm paid the sanction. I think they did the right thing. They terminated the lawyer. And, like Shahrad said, it's shocking to be that a lawyer will get so invested, personally invested in the case to take that kind of a risk. It's just a case. There's going to be another one right after that one finishes. And so I caution all lawyers who are thinking about doing something like that, when you personally invest in a case like that, the consequences can be really high and very long lasting, and it's just not worth it.
Well, let me just add one other piece to this. I've seen this a lot in terms of defense lawyers not properly disclosing insurance policy limits. And we see this a lot when there's an institutional defendant involved and they don't want their coverage limits to be disclosed. And then we get verified discovery responses that basically don't tell the truth about the policies that are involved. And then you take a PMK deposition or PMQ deposition, and it comes out that those weren't true. These are all things that are sanctionable approaches that are being taken. And the defense, the lawyers need to understand that they can't be doing this, that it's not appropriate. But also the plaintiffs' lawyers need to understand that they have leverage to essentially put pressure on when this kind of conduct is taking place. And we have to look at the field sort of in a wider spectrum to try to make sure that our clients' rights are protected.
Well, as we kind of transition to the more technology side of things and lawyers behaving badly, I thought another article, Shahrad, I think you actually did all the articles but one in terms of news for this episode. And this is one that you sent a while back. This piece I thought was really interesting because we've heard so much from the appellate courts across the board on sanctions against lawyers for AI hallucination citations. And so we see appellate courts, federal courts, trial courts issuing sanctions. We haven't seen a lot of kind of the follow-on, which is state bar prosecutions, and now we have. And so that was the article that you brought forward, that the state bar in California has filed charges against 3 lawyers for fake citations from AI-generated material.
It's interesting that that's what they're doing, because I would think that the trial courts would be more involved than the state bar. But I think the state bar is taking that approach, which is interesting. And, hopefully they're not watching, but considering the bar exam debacle, it's kind of interesting that they're charging these lawyers for hallucinations. But
You've
it also
described yourself an investigation, sir.
yeah. But also the other issue is that now there's at least 2 courts down in the Los Angeles area who are now testing out AI for drafting orders and doing some of the things that typically I would think the research attorneys would be doing. So it kind of comes full circle with all of it. And I think there's bound to be mistakes by AI that then humans miss. And how does that turn into a state bar prosecution, and what's the threshold that they have to apply?
Yeah. Marshall, are you seeing more of this on your side, given your firm's background?
So I haven't received any, but I'm on various email chains and listservs where I am seeing more and more. I was aware of the article that came out. And I think that the pace at which courts are sanctioning lawyers is increasing, which again, every time I think we've been on this podcast from inception, it's continued to rise. So lawyers are still doing it. And what that tells me is I think there are lawyers in general are aware by now about hallucinations. But what I think is happening is that they think the service they're using is perhaps safe, or they're misconstruing the holdings. Because I know that the Westlaw version, Co-Counsel, I remember, Miles, perhaps it was even the first one you and I did, the first CLE, where I would stand up to a bunch of people and say that Co-Counsel was hallucination free. They would advertise it as such because it's a closed system. It's not open source. But what Co-Counsel does is it's going to give you a real citation, but it might pull from the dissent, and you might cite that for a majority position. Or it might misconstrue the holding or just get confused about what the issues are. And so you're citing a case that exists, but the analysis is completely wrong. I think that's the same problem that these lawyers are falling into. And I just think the biggest, red flag of all is just don't use it for brief writing and case citations. And or at a minimum, vet the cases and certainly make sure the holding is what it stands for, and the analysis above the holding and below the holding is consistent with the holding. So that's, I think, what this sort of data is telling me. Because otherwise, people are just not watching or taking any CLEs on AI and just have no clue. But I just kind of find that hard to believe now, given every other email I get about a CLE has to do with AI. And obviously, hallucinations are going to be a part of that.
A transition on AI and AI use. You brought up Co-Counsel just now, Marshall. Also in the news very recently is that Anthropic's Claude has reached a deal with Thomson Reuters Westlaw so that Claude will be connecting with Co-Counsel Legal. And on that side, it's interesting when one says to not draft with AI. That's exactly what a Claude Co-Counsel 1.2 is doing, most likely, because it gives you the opportunity to use previous work product to then ape your style for motions to compel, summary judgment, et cetera, and draw out of Co-Counsel at the same time. So I recognize that hallucinations remain a problem, and there seems to be more and more of a trend from the vendor side to make it easier and easier to use these tools as a first step that still require human review.
And I'm all for it, right? I'm all for them partnering up and allowing for brief writing to become easier and more efficient and adopt your styles, as you say, and make it easier for you to use your own firm's brief banks that exist. All of those things are amazing. It just all still requires diligence, which I think it's also remarkable just how fast we as humans let our guard down. It's not unique to lawyers, right? We as humans, just using AI in general across however you might use it, medical advice, you just let your guard down. And I think that's the problem. But unfortunately, we have licenses that could be taken away from us for misusing it. So the bar is just higher. And so with that partnership, I think comes a greater responsibility. But I'm all for using it, but you just got to check it.
So I think we have to talk about a couple of different things in this context. One of them is when we first started this podcast, it was basically, hey, what can AI do? You just go in and you ask it a question and it'll give you some answer. Now we're talking about agentic AI. So now if you're using Claude, you have the tab, if you have it on your computer, there's Claude Chat, there's Claude Cowork, and there's Claude Code. So Cowork, you can actually make it an agent that can do things for you. It can access stuff on your computer and all this other stuff. So now we are changing it. It's almost like an assistant or a junior associate. And the question that leads me to is that with this going forward so rapidly and changing so rapidly, how, as people who are supervising younger attorneys, do we train those attorneys to, one, keep their critical thinking skills, but also be able to embrace the technology that's there for our small firms to be able to stand up to firms that have 1,000 or 2,000 lawyers? So that's the critical question that I think we all have to grapple with. And I think the answer that we're, might be giving today is going to be different a month from now or 2 months from now.
Yeah, I agree with you. I remember years ago, months ago, time flies, right, Shahrad? When you talked about while the cost of a very high-end AI service might be equal to a low payroll employee, it can make up sometimes in some ways for, say, a junior paralegal, and you got to treat it as such with any content that comes out of it. And my impression is, as things get agentic, that thought process remains true. That we can use these tools, but we can't use these tools to the point where we no longer can move quickly on our feet with the same information. And we have talked about this in the past. The studies that show that if you take a bunch of articles that an expert wrote and dump it into AI, it's not, and it gives you a digest, you're not going to have the same granularity as if you read those articles to prepare for that deposition. And is it beneficial to sometimes have to be ready for 30 expert depositions very quickly and use summary services? Yes. And are you going to get better mastery of information when you do the work yourself? Also, yes.
But I think it's a cost benefit, right? It's short term versus long term. The short term success might be what you need, right? You might need to prep for those 30 depots, but long term, I think it's bad. I think that looking down the line 10 years from now, as AI fully is ingrained in what we do, each of our offices will have systems in place that, like you said, Claude co-work and things like that are analyzing our own files and organizing so we don't do it anymore. Thinking on your feet is going to become a lot more difficult with respect to the universe of whatever case you're working on and making arguments, because we're becoming accustomed to AI doing it for us so we don't have to do it, which is great in the short term. But I think it's going to be very interesting to see how the long term shakes out when lawyers are standing up in court who became lawyers, right now or 2 years ago as this was getting off the ground, and never had to dive through Westlaw and search case after case to find the answers and find the wrong answers only to then get to the right answers, where it's just immediately right at their fingertips, or so they think. So it should be interesting.
So let me put you guys on the spot. What advice would you give young lawyers that are coming up right now who are facing this issue?
I think one thing I would say is work for lawyers who have the experience, the trial experience, the lawyering experience that predates that. So you can at least see how they operate and learn the various anecdotes that they have to give you. I think that's one thing I would say.
It's hard for me, Shahrad. And it's hard because I don't want to be a guy in the buggy whip building business while cars are coming telling folks that they still need to know how to make buggy whips.
Mm-hmm.
So for me, my knee-jerk response is learn to write, learn to think, and learn to be able to do it yourself without lots of crutches. And at the same time, the analogy that I was going to throw out to the two of you is phone numbers. So here's the piece that popped to mind. I used to know the phone numbers of all the people who I called on a regular basis. I actually have kind of a demarcation point. So Cynthia McGuinn, the woman who was my mentor, I still can call. I can put her number into a phone, and from kind of a certain point forward, no one knows anyone's phone numbers anymore by heart. Now, does that mean we can't come in contact with each other anymore? Absolutely not. On rare occasion, is it useful to have like one or two numbers, your parent or your child, where you can dial them from someone else's phone should something come up? Yes. But on the whole, the memorization of numbers has not harmed our society. The reliance on GPS to get around our built landscape is another area where we've become less reliant on road knowledge and maps. And it's a natural progression of the technologies that we have. So for us to say to the next generation of lawyers, oh, you've got to master writing. Oh, you've got to do this. You've got to do that. When what lawyering looks like, thinking will always be necessary for humans. But what lawyering looks like for the next generation could be very different than us telling them you got to do it the hard way.
Well, but they also are going to be working with us, who I think the three of us are probably a lot more tech savvy than 90% of people who have their names on the doors at these firms, right? So my take on it is learn the technology and help to enhance your skills and your firm skills. And that's how you make yourself valuable to the partners or people with names on the door. The idea that you're just going to kind of sit there helplessly and let this wave crash over you, to me, is not a good place to be. But if you can somehow use this as an enhancement of your abilities and your skill, then you're in a much better position to be the one who gets selected or keeps their job if there's layoffs coming, because AI is basically making it so that we don't need, 4 attorneys, we need 2 attorneys.
We think about, what should we be telling young lawyers? The other is, what should we be thinking about as older lawyers, or what should older lawyers be thinking about? And one of the things that has been revelatory to me, I think of myself as technologically sophisticated. And then I have some younger people in my firm who, when I'm trying to address a thing in, say, a meeting, have an answer before I can even come up with my thought on what the question is. And they're so technologically advanced that have tools that available at their fingertips that I'm not privy to. And so and I think that the phrase for this generation are digital natives, and the digital natives have a lot to offer that we should be aware of and shouldn't just look down our nose at just because we don't like TikTok or what have you.
I had a conversation with an attorney at a conference where he was so offended by the concept of AI doing legal research. He's like, "Well, when I was in law school, we went to the library, we looked through the cards." And I was like, "Wait, do you use Westlaw?" He's like, "Yeah." I'm like, "Are you still using the cards?" "No." So you have adapted. This is just the next iteration of that, of what you have to adapt to. And I think the idea that, there's this old cartoon where it's a guy standing there with a bunch of cavemen. One of them has a wheel, the other ones are pushing a cart that has square wheels on it, and they're like, "We're too busy, we can't deal with this." It's like, yeah, the wheel is there. The question is, how do you utilize it for your firm? And you're right. Dealing with younger lawyers, I mean, their command of technology is just mind blowing.
One thing I think that scares me is, in a good way, is my firm's really busy, as I'm sure yours are as well. I mean, we have so many cases coming in and so many cases to work. And with AI making it able to have one lawyer do things more efficiently, it really enables us to take on more work. And, you know, as humans, like, with email, our lives as lawyers, I think, got worse. The quality of our lives got worse, right? Because people can fire emails off all day, all night versus faxing. When business hours ended, that was it. Life for a lawyer used to, I think, be a little calmer. Right now, when you start to, be able to respond to discovery in 20 minutes versus 10 hours, how many more cases can your office handle? And is that healthy for you as a person? Is that healthy for the culture of a firm when, sure, you're able to handle all these things quicker, but if you handle more of them, you sort of find yourself in the same problem. And that's one thing I personally worry about is, bandwidth and the ability to, take on more as these things become more and more efficient, and you're not bogged down with all the tasks that used to take all that time.
I agree with you. I think there's a separate conversation that we can have about guardrails or firewalls for life. And that is, I personally wish I lived in an old timey world where, things arrived by mail and I had enough time to, think about my responses as opposed to the steady flow of email. My approach to that has been to try and limit the times that I look at email and texts so that I don't get sucked into that maelstrom. But it's very hard on that side. I think that there is a potential, as you talk through this, for increased access to justice. And what I mean by that is cases that used to potentially be inefficient for handling. Gosh, it's just going to cost too much to put, 100 hours of lawyer time into this case where you lost $20,000, whatever the number is. The ability to work cases more efficiently may lead to more cases and may lead to more cases because cases that otherwise would have been inefficient now can be brought and handled. I see some potential for opportunity there as well.
Well, it's no surprise that I think well over half their hallucinations that are being discovered in litigation are from pro se litigants.
Yeah. As we chew through topics, I did want to make sure we got to the Berkeley law ban on AI. I think it's a perfect, perhaps, omega to the alpha of this conversation, because as you pointed out, Shahrad, Berkeley now has a policy limiting artificial intelligence use.
It's interesting. So looking at the policy, I'm looking at it right now. It has bans on, for example, brainstorming a paper topic or thesis, uh, using AI tools to propose an organizational structure for a paper, prohibiting outlining. So composing paragraphs, summarizing legal rule for use in paper. So there's a whole host of things that it's banning, but it also saying instructors may deviate from the default rule for courses designated intentionally to teach AI fluency. So they're kind of having it both ways, right? You can't use it at all, but if there's a course, maybe that's allowed and the instructor can allow you to utilize it. So it'll be interesting. I'm not aware of a specific course that they teach at Berkeley Law that's specifically geared toward how you succeed in the real world using AI. So I don't know. Maybe there is a course that I'm not aware of, but it'll be interesting to see how this plays out as it unfolds.
But I think if you're a proponent of the ban, you would argue, you can't critically evaluate AI if you never developed the underlying skill yourself. How do you know if it's making a good argument, an articulate argument, if you haven't developed that skill? I mean, I think one thing everyone knows is when you go to law school, they teach you how to think like a lawyer, right? That's what you learn. And if you don't learn that skill, then when you graduate, really, how can you analyze the issues? And so I think it becomes a question of like, do you want the student to just write the best possible paper, or do you want the student to write the best possible paper that the student is capable of writing? And I think those are big differences about what a law school is looking for. And I think they want the latter. They get that they can have AI write a great paper and it's going to hit all the points. And if it doesn't hallucinate, and I'm sure in many instances they don't, but that's not what they're looking for. So I get it. Those would be, I think, two strong arguments in favor.
I get it. And with law schools being as competitive as they are, a policy like this feels a little bit like a 65-mile-an-hour speed limit that then means 90% of the people out on the highway are violating the law. I see the likelihood that it will make everyone a rule breaker at some point. And that is a concern I have with a blanket policy along those lines.
Yeah, I think it's a big broad stroke brush that they just.
Well, and here's the other thing. I mean, this is all interesting, but so it says, at the tail end of it, it says the use of AI is prohibited for aid in conceptualizing, outlining, drafting, revising, translating, or editing any work submitted for credit. What it doesn't say is that it's outlining research, which means that, as we all know, both Lexis and Westlaw gave us free access to our heart's content to hook us on their platforms. And it doesn't say you can't use AI for research that then goes into your documents. And most of these, even the non-Co-Counsel AI section of Westlaw, is almost drafting stuff for you when they spit out that research memo. So that's going to be, policing this is going to be incredibly difficult, in my opinion.
I see huge challenges in how it's going to get policed. I think I mentioned, and I don't know to the extent the two of you have seen this from your kids and school. What I'm seeing now in school from our young ones is step-by-step requirements. We need to see you handwrite your outline. We need to see you write your topic sentences. We need, and so there's so many demarcation points where the teacher needs to see the work product before there's a final paper. And the sole reason they're doing that is to eliminate the ability for someone to turn in a paper straight from AI.
Well, and I don't know if you guys have heard this, but it's my understanding at colleges now, you're required to write your paper on platforms that then can track every keystroke. And if you cut and paste, it can tell, and it knows how long you waited between sentences and all this stuff. And all of that is built in to try to reduce the chance that somebody's just cutting and pasting from AI to turn in a paper.
That's not going to increase any anxiety for any of our kids who are worried about being spied on.
Not at all.
Well, as always, I love thinking, and I love the thought process and thought exercise that we have when we go through these topics. So, thanks both for the contributions.
As always,
Thank you.
As always, glad to be back, and it's fun to think alongside you two gentlemen as well.
I think our avatars are looking a lot more realistic these days. So,
and thank you for listening today. If you like what you've heard, consider sharing this with a friend and giving us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.